Welcome to this presentation covering labor law. So let's get started. We're near the end, so I'm going to fast forward to talk about Taft-Hartley, which is an amendment to the NLRA to the Wagner Act. And so we'll see kind of what was going on at that time and what might have motivated some of these changes. Okay, so let's look at Taft-Hartley. All right, here's an overview. I guess let's first of all summarize where we've been. We've talked a little bit about the history. We gave an overview of the first iteration of the National Labor Relations Act, which is usually called the Wagner Act, and we talked about the topic of concerted activity, both by unionized employees and also by non-unionized employees. We talked about the union campaign and election process, which is pretty darn thrilling, and we talked about collective bargaining, which is almost as thrilling, about that give and take process. And we talked about, well, what happens if you can't get an agreement? Well, one of the things that can happen is there can be a strike or a lockout. We talked about the idea of unfair labor practices, actually several different points along the line, and we'll talk about it some more in Taft-Hartley. But this can arise during the union campaign, it can arise during the collective bargaining agreement, it can arise during a strike or a lockout. It can even arise before a union campaign occurs, such as when there's concerted activity. So the ULP issue can arise in lots of different contexts. It can be an unfair labor practice by the employer, or it can be an unfair labor practice by the union. So let's go now and talk about Taft-Hartley. So now we are after the Wagner Act has been in effect for, a decade or so, a little more than a decade, and now the Congress is amending amending the Wagner Act to respond to concerns about union abuses. And the idea is, well, maybe we didn't have the right balance between the power of unions versus the power of corporations, the employers. And obviously it's a delicate balance. If one's too powerful, you're going to result in kind of lopsided results. So there's kind of a negotiation or a rebalancing of that power. At least that was the goal of Taft-Hartley. Taft-Hartley has, of course, obviously those are names of two influential congressmen who were around in that time period. The actual official name of the act is the Labor Management Relations Act. I've never heard anyone call it that, though. Taft-Hartley is what people call it. And so when people talk about Taft-Hartley, they're talking about the corrections or the adjustments that were used to kind of rebalance the authority and take away some of the authority from the union and give more to the employers. Okay, so let's look at some of the aspects of this law. First of all, it outlawed closed shops. And this is something, again, that is illegal now, but it wasn't illegal in the early days of unionization. Now, this is different than union shops. We've talked about closed shops before, but let me just do a refresher. This is when you might have a collective bargaining agreement, a provision in it that the employer says, we agree we're only going to hire current union members. And you have to, and then those people have to remain a member of the union throughout their employment. Well, the second part, that's okay. That's just a union shop, and I mean it's okay in non-right to work states. But this first part is unlawful because it really gives the the union, the ability to control who's going to be an employee. So let's say that I want to work for ABC Company. But I'm not good friends with the head of the union. Well, that head of the union can essentially stop me from working for the employer because the union can just say, no, we're not going to let you be a member of the union. And so therefore you can't ever be eligible for employment. So that type of arrangement is not permitted. Again, the union shop is okay in non-right to work states because the union has to let the employee hired by the employer to join the union during that 30-day period right when they are first hired. So the union can be sure of getting an income stream, the union dues, in those situations, but the union doesn't have any power to force the employer to take an employee that it doesn't want, or it doesn't have the power to stop an employer from hiring a particular employee. The Taft-Hartley also prohibited supervisory employees from joining the union, so that there was that clear separation now between hourly and the supervisors in management. Let's talk about the issue of a secondary boycott. Imagine that one facility is unionized. We'll say Bob's factory is unionized. Bob's factory perhaps uses FedEx as its trucking company to take orders out from there. Well, FedEx is not unionized. So the union who is in place at Bob's factory might want Bob to switch to using UPS, which is a union shop. And so the union might say, well, we're going to strike you unless you switch. And that would be unlawful, because the dispute that the union at Bob's factory has isn't with Bob, it's with this other employer. And really, at least from a matter of law, it shouldn't be the union's business what entities Bob wants to contract with and whether they're a union shop or not. So basically that has to do with the management of the business, and the unions who are trying to tell the owners of the business how to manage it, that qualifies as a secondary boycott. Now, let me correct that and make it a little clearer. Unions can tell the company what they think the company ought to do. There's no problem with that, but it's when they're using their economic force to kind of force a company to do something. So it's the boycott side. So giving advice is fine, but the secondary boycott is prohibited. So it's a boycott by a union in support of a strike initiated by workers in another enterprise. And there actually doesn't have to be another strike. It could be, there may not be any dispute at FedEx. There may be no interest in FedEx employees of joining the union, but it's just simply the rejection of or trying to make FedEx go out of business, or trying to pressure FedEx to become a union employer. Also, union members had to certify that they were not communists. Keep in mind that the world was a really different place back in 1947. We had just ended World War II. Communism was a very scary thing. There was Stalin in Moscow. There was Mao Zedong in China. There were lots of concerns that this communism might spread, and of course it was spreading in some sense. This is of course before Korea and before Vietnam, and so that threat was perceived in a very different way than we would perceive it today. So that concern, and I think another aspect of the concern was nowadays when somebody said, or if someone were to say they were a communist, we kind of consider them maybe a little bit odd. But communism in some circles was a pretty reputable, reasonable belief system to have. And so it was entirely possible, and in fact it was true, that there were unionists who were communists, card-carrying members of the Communist Party. So it wasn't as strange of a thing to mention as we would now think of it being. Make union shop agreements illegal if they are contrary to state law. This is that right to work thing. Again, we said about half the states are right to work and about half the states aren't right to work. They're union security states. I've already covered the ins and outs of right to work versus union security, so I'm not going to do it again. I'm just going to remind you that Texas is a right to work state. And again, this has nothing to do with employment at will. Be sure in your mind that you know the difference between those two. Again, if you're not clear about that, go ahead and go to one of the earlier lectures so you can be refreshed on that. Another aspect of Taft-Hartley was that the unions were required to start filing financial reports with the Department of Labor. So the Department of Labor had some degree of oversight. Now, I don't know historically what the Department of Labor has actually done with these reports, but I will tell you what employers do with these reports. They use them in union campaigns. So when you happen to have a union activity, and let's say you're the employer and the union is trying to organize your workplace, well, you request these LM2s, and there are other documents, but one of them is these LM2s to get information about the union. So you can see things like, how much does the president of the local earn? How many people with the same last name are the secretary and the vice president and the president of the union? How much money do they spend on political activities? And so it can be useful information, because think about it, the potential or the people that are going to be voting in the union election are interested to hear what the union is going to do with their dues if they happen to end up joining the union. And so if the union is a wise uh, uh, guardian of their funds, a wise investor of the money, then that's a good story for the union to tell. If, on the other hand, the union doesn't make wise choices, then that's a story that the employer might want to tell. Another thing that stopped, this sounds a little startling, but that employers would pay money to union officials. There was a fair amount of corruption, both with the corporations and with the union. So imagine that the rank and file members wanted a $3 an hour raise. The employer might give the union official $1,000, and suddenly the union officials are going to agree to a 50-cent raise. So you can see how, if the union official could be bought and the employer was willing to buy, there could be an opportunity there. And that, of course, that type of bribery, it became illegal under Taft-Hartley. Unions stopped being able to, or had to bargain in good faith, just like the employers had always been required to bargain in good faith, and now the union had to too. So this was kind of, again, that balancing of the authority. So for example, the union couldn't just decide not to attend bargaining sessions. The unions couldn't just decide not to provide any proposals or not give information that could affect the company's proposals. Most of the time it's the company giving data to the union about maybe the profitability of products, the profitability of the company overall, but there could be issues that the union might have, or information the union might have that the employer might also want. And that information has to be shared so that both sides can develop their bargaining positions. We've also talked about these. The union can't engage in secondary boycotts. They can't require excessive initiation dues or excessive initiation fees or dues, or even excessive fines. Now, what that standard is going to turn on the industry and what the earnings are in that particular market. Another is that they can't engage in feather bedding, hiring more workers than is needed to perform a given job. You know, as technology has progressed, a job that might once have taken 10 workers to do might now only take 1 or 2 workers to do. And so the idea is that you need to move to 1 or 2 workers. At times in the history of unionism, the union would say, okay, that's fine. You may only need 1 worker, but you're going to pay all 10, and they're going to stand there and watch the 1 worker watch. That's the feather bedding idea, and that became unlawful. Finally, or at least on this list, finally, the union cannot enter into a hot cargo agreement with the employer. And what is a hot cargo agreement? It's an agreement between the union and the employer that bars the employer from using the products made in a non-union shop. So the non-union shop, as its stuff becomes like a hot potato, like hot cargo. So the employer might, for example, let's imagine that the employer is making toasters, and one of the components that it needs for the toasters is a widget. And so the employer has sought bids for these, and the lowest price, best bid was from a non-union facility. And so they've entered into a contract to provide the widgets for the toasters that are going to be assembled by the union workers in this facility. Well, there can't be a provision in that contract that would limit the ability of the employer to source those widgets from that non-union facility. And so that would be unlawful to treat that non-union good as if it were a hot potato or a hot cargo. That's an illegal arrangement. Okay, so now we've talked about the Wagner Act, we talked about the Taft-Hartley Act, and now we're going to talk about the Landrum Griffin Act. Excuse me. Again, you don't need to know the other name. This name's a little bit more familiar. I've seen the Labor Management Reporting and Disclosure Act, but usually it's Landrum Griffin Act. This is several years later, a little over 10 years later. And this is, in the era, again, of actually, this was something that Bobby Kennedy was very involved with rooting out corruption in the unions. The Taft-Hartley was designed to address some of that, but there were still some ties with the organized crime and other groups. You may have heard of the person Jimmy Hoffa, and he was one of many people that had uh, perhaps at times done good things for workers, but had also gotten involved in things that were unlawful and had resulted in some corruption. So there were these congressional hearings that uncovered much of the corruption, and so this resulted in concerns about union members. I mean, obviously the vast majority of union members were good citizens who were being taken advantage of in the instances in which their union was corrupt. And certainly no one believed that all unions were corrupt or all union officials were corrupt. But there was that component to that particular organization, again, in the 50s. And so one of the things was, well, how can we protect the union members from the possibility of having a corrupt president or corrupt leadership within the union? And also part of that was, how can we make sure that the elections are fair? I mean, if you have unfair election procedures, it might be, almost like, what for example happened in Iraq when Saddam Hussein was the leader. Yeah, they had elections, and every time Saddam Hussein won in a landslide, but not because the people really wanted him to win, but because they were afraid. They thought if they voted against him that they might be killed. And so as a result, everyone voted for him, but that's not really democracy. Well, that same type of concern sometimes existed within unions. And so there was a lot of difficulty sometimes voting out corrupt or unethical leadership. And so the unethical leader would then get his friends or her friends or the family into various positions of power, and so it kind of perpetuated itself over time. So one of the rights that union members has is the right to attend all union meetings. If it's a meeting, the person could not be barred at the door, even if they weren't popular with the leadership. They also have the right to vote on all union business. So they had the opportunity to express their opinion. They had the right to nominate candidates for various union positions. They had the right to a full and fair hearing when disciplined by the union. The unions had the ability to discipline members, for example, for not paying the fines, or for not following whatever the rules might be, the membership requirements. Okay, so let's look at what protections were being afforded through changes in how the unions were managed. So one was safeguards for protecting union funds and assets. There had to be a full disclosure of the accounting, and this information had to be provided to the Department of Labor. So again, this was a public record that union members could access to see, well, where was my money going to? Union funds could not be used to support union candidates in their union elections. So if I'm running for president of the union, I can't use union money to support my election offers. And then there's the notion that there was a fiduciary responsibility that every union officer had for handling the assets and the affairs of the union. If I'm receiving the dues, I can't use those to, pay for my trip, to Paris or something. I need to use it on union business. Now, obviously, I'm going to get a paycheck. Certainly, that's reasonable. But I can't be flittering the money on things that are not in the best interest of the union members. Let's talk a little bit about private sector unions. The whole notion of unions in the private sector is kind of based upon some fundamentally different ideas. In the private sector, the largest motivation is profit. And so an employer is interested in maximizing you know, the profitability of the business. And so when he or she considers how much to pay his or her workers or what benefits to offer, it's really thinking about it from the perspective of, well, if I you know, offer too low of a rate, I won't have enough workers, or I will have lower quality workers. Those are the only people that will seek employment. If I offer too high of a rate, I'll have lots of people showing up wanting work and lots of really high quality people, but I won't make as much of a profit because I will have so much salary costs associated with it. So the employer is looking for that perfect balance where you get good people, but you're not paying more than you need to, and so you can still turn a good profit. A government, though, doesn't really work in that way, because the government isn't looking in terms of profitability. Obviously, a government department wants high quality people, and naturally or hopefully doesn't want to waste our tax dollars. But there isn't kind of a market process that's going to address that. Another reason that so those aspects are one of the reasons why employers are sometimes reluctant to be in favor of unionization. They're concerned that that perfect balance between how many people to employ and what hourly rate to pay them at will now be more difficult for them to manage. They won't be able to respond as fully to the economic situations at the time, because they'll have to also respond to the union. The governmental entities don't have that economic pressure, at least not to the same extent that private entities do. And another factor is that they are really doing this, or they're kind of in business to please the electorate, the people voting for it. And so it's difficult for a governmental entity to be nearly as vocal about its opposition to unions, because there are going to be people out there voting in the election who support unions. And so if they're a proud union member and they see that their government is trying to oppose government workers joining a union, then there's that notion of, well, gosh, I mean, I think unions are great and my tax dollars are being spent to avoid unionization, and I don't like that. On the other hand, people who don't want unions are not nearly going to be as focused on it. It's kind of a special interest group union, so that they're really focused on this issue. Everyone else is kind of like, oh, you know, I don't have that strong a feeling one way or the other. So the government is much more likely to offend those individuals if they oppose unionization than delight the people who are maybe mildly opposed to unionization. So as a result, government entities usually don't really stop or don't try to stop the workers from entering into unionization. Another reason that unionization in the public sector isn't as is much more common and isn't as controversial is that the employees have significantly fewer rights even when they are in a union. Many states have collective bargaining statutes that discusses what the public employees can do if they are members of a union. Texas, however, is not one of those states. The most important difference between public and private collective bargaining is that under federal legislation, federal statute, and most state statutes, there is no right for public employees to strike. Those of y'all that are a little older may remember in the 1980s, the air traffic controller struck. And at that time, our president was Ronald Reagan, and he fired them all. The union was called PATCO, and they did not have the right to strike. And so as a result, everyone who struck was no longer eligible for employment. That, of course, would not be the way that it would work in the private sector. People can strike, they can be permanently replaced, but they're entitled to their spot once they make an unconditional offer to return to work. If they're economic strikers, they have to wait until their replacement is it leaves, but if they're ULP strikers, unfair labor practice strikers, then they are entitled to reinstatement just as soon as they make that unconditional offer of reinstatement. And so, but under the labor situation with the air traffic controllers, they were all banned from returning to work as air traffic controllers. So that's an example of how just a very big difference between federal unions and private sector unions. So let's go over a few management tips here. If employees seem to be considering unions, you don't want to interfere with the process. You really want to just kind of run to an attorney who specializes in labor work, and kind of don't do anything until you talk to him or her. But you have to run, because the reality is if you're just finding out about it now, it's probably been going on for weeks, or very possibly has been going on for weeks, because oftentimes the employers don't know until quite a while, because the union is trying to keep it a secret. Also, don't assume that employees you speak to are going to keep the conversation confidential. Whatever you say, assume it will be heard by the union. Also, when you talk to an employee, assume that they have an ulterior motive for whatever they say. They may be anti-union, they may be pro-union, but what they say does not necessarily correspond to what they actually think. Another thing to definitely assume is that there's more union support than you know about. It's just the nature of the human experience that when the employees know that the company opposes unionization, employees who support the union are not going to admit to it. They're not going to admit to it because they don't want to be retaliated against, number one. Number two, they may not admit to it just because it's awkward to be in disagreement with your employer. So that's a second reason. A third reason is some of them are kind of spies. They have been enlisted by the union, or maybe they're doing this on their own to kind of find out what's going on, and they know they're much more likely to get information if they appear to be anti-union. So for all of those reasons, you ought to assume that anyone that you talk to, unless you have very, very good reason, many years of knowledge of their perspectives, that they are in fact reliable in these areas. Reliable in terms of the views they express. Obviously, both anti-union and pro-union folks can be reliable, decent, honorable people. I'm not saying the morality goes one way or the other. Both groups can be, but both groups have the potential to be sneaky and to be a little bit into kind of some cloak and dagger efforts. You need to know what employers can do, what they can do, and what they can't do. And you have to be really, really careful to not cross the line. And more importantly, you have to make sure that your managers and your supervisors know this, and not just know what they can and cannot do, but know that they will be subject to severe sanctions if they cross the line, that it's not forgivable if they mess up in this area. And so you have to really be conscientious about training, and also conscientious about letting people know where the line is and what can happen if it's crossed. Keep the lines of communication open. This isn't just during the union campaign, it's well before the union campaign. We'll have lots of ways that employees can talk to management, formal and informal, lots of different paths, lots of different people that the hourly folks can talk to. I'd like to close with the idea, it's a common saying that you'll see in the labor biz, that employers often get the union they deserve. Employers who treat their work staff the way that they want to be treated, who treat their employees with dignity and respect, who pay a fair wage and offer reasonable benefits, usually find that they aren't going to be subject to union campaigns. So there are certain parts of the country that really are highly unionized, and so you may still get the union campaign. But if you're a good employer, that takes a pretty good amount of the steam out of the engine of the union campaign. It's usually when the union is most successful when the employer hasn't been doing the right things by its employees. So the best union avoidance strategy is to be a good and decent and honorable employer. So on that note, I'm going to close our labor law presentation. If you have questions, of course, feel free to send me an email. My email is cgroover@collin.edu, or better yet, come by. As you probably have been able to ascertain, I have a passion for this topic. I find labor law very, very interesting, and I would be delighted to talk to you in more detail about it. Thank you for your attention, and I hope you have a wonderful day. Bye-bye.